Okay, we've returned for part two. So where have we gotten? The law says that people can separate judgments of liability from judgment of damages. Our research, among many other people's research, find this isn't the case, right? So, experimental research demonstrates outcome severity determines perception of responsibility and acknowledgement of extenuating circumstances. So, here's a general formula. The more severe the outcome, the more severe the injury, the more responsibility has to be put on somebody. That is, we're just driven to do this. The more severe it is, we got to find someone to pay, right? So, responsibility, the need to find responsibility goes up, and if you need to find someone responsible, then you need to minimize the impact of excuses, alibis, etc. So you have two things going. The more severe the outcome, the more we want to find someone to punish, and the less willing we are to entertain excuses. And this is just basic cognitive mechanisms that operate within this domain. Very difficult to make people aware of this and make people correct for it. And remember, Wilson and Brecky, we might be able to make people aware of it. They might be motivated to correct their bias, but their correction will always fall short of what it should have been. So, why is it so hard? Well, there's a couple reasons. I mean, there's more reasons than this, but some example reasons. Why is it so hard to separate liability from injuries suffered? Well, we have sorrow for the plaintiff. We're looking at someone, some poor unfortunate person who's been injured, right? And we want to make the world right for them. Right? Defensive attributions. The more severe the outcome, the more we want to pin responsibility on someone. And this is also like belief in a just world. And this is such a horrible situation, someone's got to pay. Someone's got to pay. Someone's got to pay for this. And that's kind of the mantra as it becomes. Okay. Let's move on to another topic. Judge's instructions to the jury. The judge usually reads them aloud. Jurors can't ask questions during the reading, and judges can't paraphrase too much. So the courts develop jury instructions, and the judge typically just reads them verbatim. And the judge really needs to read them verbatim, because if the judge paraphrases too much, it opens up the door for appeals if the defendant is found guilty at some point in the future. You can't stray from those, because then they'll just say, well, you know, this paraphrasing, and suddenly they've opened the door to appeals. So judges really don't want to go down that road. They read the instructions. Hey, you're good. Let's go on with the trial, right? Generally don't understand 40 to 45% of them, and this is an easy research to do. You take judges' instructions, right? You have participants read the judge's instructions in the laboratory. You give them a quiz on the instructions, and what is their score? 40 to 45%. How you guys doing? What are you doing? If you do a test and you come back with 40, 45%, what do we call that? Yeah, in a generous course it's a D, right? In most cases it's an E, not too good. But this is what we can expect of juror comprehension of the instructions. Now, if we read them at the beginning of the trial, we're better off than when it's typically done, which is right before the trial, right when all the evidence has been presented, the closing statements have been presented, now the jury's about to go deliberate. What do? And we read the instructions. Not so good, right? So, why might doing it at the beginning of the trial be a benefit? Well, it sets up the appropriate framework or schemas. That is, again, people are in an ambiguous situation. They don't necessarily know what's expected of them. To read them the instructions in the very beginning allows them to set up a framework or a schema that incorporates those instructions, rather than trying to incorporate those instructions after the trial has taken place. So it probably leads to better decisions. That one's probably pretty easy to test. A better recall might not be so much, right? So you'd have to separate those out. Leads jurors to hold off verdict decisions until the end of the trial, and this is most important. Remember, we talked about the way people process evidence, and we talked about, I believe it was it was the Casson study, right, where people had a dial that they could tilt towards guilt, they could tilt towards innocent at any moment as they're hearing evidence during the ongoing mock trial, right? Well, if we read them at the beginning, then maybe people just leave that dial in the middle where it belongs and don't so much try and figure out guilt or innocence as they're going along. And it's likely that hearing the instructions beforehand now allows course facts to be better aligned with the law as the judge instructed. So the story model, let's kind of put the big package on this, right? Tie a little bow around it. This is a theoretical cognitive process involved in juror decision making. If we look at jurors as active and similar to construction of a story narrative, that this is what we do. We try to make sense of our world in kind of this ongoing flow of information. So we're not suspending judgment. We might move our judgment as we gain additional or new information. But the idea is jurors don't sit back and just absorb evidence. They're always working on fitting it into a preferred story, some kind of narrative to make sense of their world. Demonstration for this is from Olson, Falero et al. Rape case stories, right? People with different verdicts remembered the evidence differently. So if we compare the people who vote not guilty versus the people who vote guilty, we see that their recall, the stories that led them to that verdict, differ, right? So the story model then, that's good evidence for it. How do we know story making happens? Well, Pennington and Hastie manipulated the same, used the same evidence, but they manipulated it in different order, and they came out with different outcomes as far as verdicts go. So, bottom line, jurors are active information processors. They're not really suspending judgment till the end, as they're supposed to. Hear everything and then pass judgment. They're basically passing judgment and then modifying that judgment to some degree as the trial unfolds. The problem is, the greater strength with which they hold their story, the less amenable that story is to modifications on the basis of ever-evolving or new evidence. Okay? Now, this last part here, this part of research that I want to talk about is how threats to the social order might affect jury decision making. And this is work that I did with Tetlock and Rucker and Amanda Scott. What we're looking at is the general premise is, as we believe that a crime becomes more threatening to what we hold near and dear, our sense of safety, our sense of security, a sense that the world is a fair place, to the extent that that is violated, right? Hi, Annika. To the extent that that is violated, right, then we might see people making decisions in a different regard. If I feel that a crime was so threatening, it causes me to want to first find someone to pay for that crime. And second, if I find someone to pay for that crime, it makes me then want to punish them more severely, right? So how did we test this? This cat is crazy. She loves to be held like this. Right? Yeah, Monica. So, let us then talk about how we did this. We thought long and hard. How are we going to manipulate people's perception that the social order is under threat? And one thing I suggested is, hey, what if we tell people that the arrest rate for the crime is high or low? That is, if the arrest rate for a crime is high, then we should have a sense that all is well, that the police have it and the government has it under control. But what happens if the arrest rate for a crime is low? Then it might represent a bigger threat to folks. They might be more and more concerned about the danger that this crime presents. So we randomly assigned people to a condition where the arrest rate was 8%, and this is a low arrest rate, and we even said this in the priming materials and the general statement about it. Or when we just flipped around, we told the other half of the participants that the arrest rate was 92%, which is high. You might call this a high closure rate in terms of how many people are actually eventually arrested and punished. We did a couple different crimes, which we found was important to do, and I'm going to tell you a little bit about that. Let's take the first crime, was carjacking. And this is how the initial instructions to the participants, this is the first set of instructions, this is the general, then they'll read about a specific crime. But general instruction for people in the high threat condition. And notice it's tricky because 8% means high threat, right? 92% means low threat. Okay. So size and scope of the problem, this is the actual materials participants received. Less than 8% of the estimated carjackers are ever arrested because of the large number of carjackings, speed with which the crime is committed. Few carjackers are ever arrested, and even fewer are successfully prosecuted. And because of this, the crime mostly goes unpunished. So that creates in the participants, supposed to create the perception of this crime is it a higher threat than the people who read this. Size and scope of the problem. Approximately 92% of those committing carjacking were eventually arrested because of the relatively public nature of the crime and the large number of witnesses. Most of the carjackers are arrested and successfully prosecuted and serve jail time for the crime. So this is like, hey, it's under control, nothing to worry about here, folks. And then after the participant randomly reads one of those, then they get to read the carjacking, the actual carjacking scenario, and this is what we're going to ask them to rule on. So let's see, carjacking and its consequences. While sitting at a stoplight, a carjacker forced open the driver's door of Roger Berger's car. The carjacker shoved a pistol into Roger's face and demanded that Roger get out of the car. Roger slid across the seat and fumbled with the passenger door trying to get out of the car. Just as he got out the door, the carjacker stomped on the accelerator and took off. As the car sped away, the passenger door slammed shut and Roger stood in the road watching his car disappear around the corner. What do you think about that, Annika? So, all right, now that's the body of the story. Then we make a second manipulation towards the end of the story. And remember I talked about in the date rape study the outcome severity. Well, we manipulate outcome severity almost all the time in our research to see what impact it has. So there's two different endings. Here's a low severity ending. Roger was shaken but physically unharmed. He stood in the street for a moment in disbelief that what has just happened happened, and he began to get over the shock. He was glad that at least his car was insured, and he figured his losses would be minimal. Okay. Now let's contrast that to a high severity ending. The stress of the excitement of the theft were too much for Roger. He clutched at the stabbing pain in his chest and collapsed on the pavement. By the time the paramedics arrived, Roger was dead. Yeah. That's what we would call the high severity outcome, and it doesn't get much more severe than dying. Right? We were often accused in our lab that we killed off and injured more scenario actors than any other lab in the country. This was kind of our standard stock and trade. Notice the heart attack is a consequence of the carjacking, but not a direct consequence necessarily. So anyway, that's how that's manipulated. Let's see what happens with the data. Now we have a 2x2 design. Remember, that is low threat versus high threat on the crime itself, and then severe outcome versus not severe outcome, relatively speaking. So what do we see then? Well, we see the mean prescribed punishment, which is one of the things we love to measure. Right? We see in the severe condition, that is when Roger dies, it doesn't matter. It doesn't matter whether the crime is a low threat or a high threat crime. People don't care. That is, this shit is severe, someone's going to pay, we're going to punish. Even though it was not an intentional act, we're going to punish. But notice, when Roger just watches his car drive away and say, oh, well, at least I'm insured, that is what drives the effect. That is the high threat condition. So if people believe that the crime poses a significant threat, they'll punish to a greater extent than if they believe that the crime is generally has an effective response in terms of arrest rate and punishment. Derek, I love working with Derek, and when we're writing this article, Derek used the idea that one of the things we were testing was, do severity of outcome and severity of threat cause us to double pull the trigger? That is, do we double up on the harshness of the punishment? And what Derek is showing, because this was a scale up to 7, so we don't have restriction of range here. Basically, what we're showing is, hey, one pull of the triggers has also occurred. So you activate what we call a prosecutorial mindset, which leads to greater punishment. Right? Questions about this? So it's cool. I really enjoyed this. This is one of my favorite studies that we've done. We did it with a couple other crimes. We did it with identity theft. And in that case, a woman had been saving for years to go on vacation. She'd always wanted to go on vacation, and her identity was stolen. And so just a lesser crime than carjacking was the idea. We wanted to just try different crimes, and we got the same effect, right? When her losses were irrecoverable, then in fact that was the severe condition. When she had travel insurance and it was recoverable, we saw the similar relationship based on the severity of the threat that the crime posed. Then we said, okay, so we need one more crime to publish this. We really want it, we like to package in terms of 3 crimes. And I said, let's use home invasion robbery. And that didn't work. What do you think? Why didn't home invasion robbery work as a crime within this study context? Well, when we talked home invasion robbery, all the bars, it didn't matter about the outcome, it didn't matter. Maximum punishment all the way around. The crime itself is so threatening that just overwhelmed people, and they all shifted to a prosecutorial mindset just on the basis of the crime itself. Not as the threat it posed, not the severity of the outcome, it just kind of overwhelmed everything. So we didn't include that in the study, I mean in the article. But it makes sense because it's so threatening and it's so severe that people just react all the way on it, regardless. Okay. So what are some potential reforms? And if I was to ask you, hey, you know, what are some reforms that you would like to suggest? And remember that your third discussion board talks about reforms and ideas across the entire course. This might be one area that you could consider, right? When we talk about reforming how a jury operates, some reforms do take into account the fact that jurors are active information processors, are susceptible to the story model, do use schemas, might be biased, might use stereotypes, right? That they're active information processors, they're not passive, right? So, a couple reforms that are probably relatively easy to do, some more easy than others. Pre-instructions, that is, people could be instructed before they hear opening statements, right? So we could make sure that instructions are always given right off the bat. Jurors could be supplied with written copies of the instructions. Notice this doesn't then require paraphrasing. They have written copies that they can refer to throughout the trial. Right? Should we allow jurors to take notes? And this is something that's being tested in some jurisdiction. That is, can you imagine sitting through a 2-week trial and not being able to take notes? And then go into deliberations and argue with your fellow jurors about evidence when you don't necessarily have notes. What were you thinking at the time? Right? So maybe allowing jurors to take notes. This is a beautiful research opportunity because we could do this in the laboratory as well. Should we allow jurors to discuss the case during trial? Now this is more problematic, and this is pushing the bar a little bit more. Should, let's say, we end the trial every day at 4 p.m. and then allow the jurors to meet from like 4:10 to 5 p.m. to discuss what's transpired so far. And that is allow the jurors to discuss, have an ongoing stream of conversation about the case, which is not allowed at this point. What would the outcome be? What would it do? And notice this is the beauty of being a social scientist, is you can ask these questions and you don't have to have an answer. In fact, in initial studies you probably shouldn't have an answer. Is you just run it and find out. And then once you find out, then you turn what you found out into a hypothesis and you confirm it, you do confirmatory hypothesis testing at that point. So, should jurors be allowed to ask questions? And this is, this would be kind of an interesting idea. And again, it's something that should be tested because who the hell knows how it would work out, right? But should a juror be able to, let's say, write a question about something they're hearing right now, perhaps hand it to the bailiff takes it over to the judge, and if the judge feels it's so warranted, then ask that question on behalf of the jury right then and there. I can see where this might really complicate how the trial process unfolds, but I think it's something worth considering. Should we simplify the language in the jury instructions? And that's something that could be tested quite easily as well. So we take it a little less out of legalese and a little more into normal human speech. But then that might, in fact, cause problems of its own and open up the door for grounds for appeal, or people will argue about the ambiguity of the new instructions. So who knows? Big problem with all of this, and it goes back to the fourth dilemma, but kind of at a different angle than we've necessarily been talking about it, is most people distrust psychologists and psychology studies. This shit is, that we do is easily dismissed, and it's dismissed all the time. You hear about it in the media all the time. You hear about clinical diagnoses as being refuted all the time. So the big thing is that we need to replicate studies, and we need to do a good job of replicating studies, and people need a better science education to understand how studies are being crafted and what exactly they say. And the news media often overstates what we find, or they often ignore, they often go, and people often have a hard time staying in their lane and in their knowledge area. There was a tweet on Twitter just today that my wife pointed out to me. Someone was saying, well, I've read the studies and about hydrochloroquine and its efficacy, etc., and I've read the studies. And then he goes on to state his qualifications for reading these studies and understanding them, because I've got a PhD in the social sciences. And my wife directed this to my attention and said, okay, so the guy's read studies on hydrochloroquine out of medical journals, and now he's commenting on the quality of those studies. And it's like, I can't do that. I'm a social scientist, just like this guy is who was in the tweet, and I could read, there's no doubt I can read studies in medical journals. I can read studies out of Lancet, etc., but I don't know how to refute those studies. I don't have the background to say, hey, this is good methodology, this is not good methodology. Hey, this finding might be problematic. Hey, this number of participants is problematic. I don't know how many participants are needed in a medical study. I can tell you how many participants are necessary in the studies I've demonstrated to you today. I need 20 to 25 people per condition. Does that flow from? I don't know, because I've not been trained in medical research. So this guy was really having a problem staying in his lane. I'm a social scientist, so let me comment on these medical studies and their reliability. And it's like, no, you can't, buddy. You're in the wrong field at the wrong time. So you need to back off and let people who've been trained in interpreting, analyzing, and determining the validity of medical studies, not social science studies, because it's a world of difference. So this is the problem for us, is we want to, as psychologists, tell our story to the world, but often people aren't trained to understand what it is we're talking about or how we came to it and understand our methodology. Fourth dilemma time. Law, what's happened in the past, right? Psychologists are often what's happening now or where are we going in the future? And that's the dilemma. So there's reforms that are possible, whether they'll be carried out or not.